for Her Majesty's Revenue and Atholl House Productions Ltd.
Yes, Mr. Gordon.
My Lord, if I may start with one piece of housekeeping. Your Lordship should have been made aware of a further authority, Matthews.
Thank you.
The reason we brought that up is it's the, subject to a very recent decision of the First-tier Tribunal. I believe it's the only time there's been any discussion as to the relationship between stages 1 and 2 of ready-mix concrete and stage 3. And that's addressing the point.
Thank you. So you'll come to that.
Between paragraphs 15 and 18, and in particular paragraph 17.
Yes, well, when I held it up, it was to show that we have it, not that we've read it. So
I read that. The second point I'd just like to raise is responding, my Lord, to a comment you made yesterday and also last week about passing ships. And I would submit that when one steps back, there is no real surprise that some authorities will refer more to the ready-mix concrete wording and some to Paul and Lorimer, because different cases are dealing with different sets of facts. And my learned friend made the submission yesterday, well, it's a case that the tax cases always refer to Hall and Lorimer. The employment tribunal cases don't. Well, I submit that that's not actually correct. One has to recognise, especially by the time the cases get to the higher courts, that the typical fare in the employment tribunal is not going to involve someone with a multiple business, because the kind of claims in the employment tribunal usually involve someone who is claiming an employment and has only one main source of income. So there's going to be an element of self-selection in the cases as one goes up. But as a result, Hall and Lorimer is not the actual facts, and the wording of Hall and Lorimer are not always relevant. But actually Matthews is an example, which we've just handed up, of a case where the revenue were trying to say this was self-employment, not employment. We can see this in the headnote. And they were very much relying, and Mr. Justice Mann found that the Hall and Lorimer line of authorities was pertinent. I also I've been very reluctant to sort of bring to your attention too many cases of the Upper Tribunal in the AT, other than for information, because at the end of the day, your Lordship's going to be deciding the law, and you're going to be much more persuaded by what the Court of Appeal and higher courts have said, rather than what's been said below. But I took the liberty last night of scanning through employment tribunal decisions, because they're now online and have been for a few years. And it would be fair to say that Hall and Lorimer, even in the ET, is regularly cited. Sometimes cited explicitly as an application or guidance as to how one applies stage 3 of ready-mix concrete. So the example I produced yesterday of varnish was not a mere exception, but just typical. Mr. Justice Chowdhury didn't sort of raise his eyebrows in his decision, say, and Hall and Lorimer has been cited. It's just part of the normal fare in the ET. And now what I intend to do is to proceed by going through these authorities and demonstrating to you why it is so clear that Hall and Lorimer and ready-mix concrete are the same sides of the same coin. So if I could ask my Lords to turn to page 97 of the authorities bundle, and I hope I won't be causing any difficulty if I refer only to the electronic bundle pages. I haven't got
we think they're the same.
They are, but I'm not going to refer to tags if that's convenient.
That's very helpful. That you should.
I'm grateful. I don't intend to read large tracts of this decision, or in fact many decisions. I'm just going, the authorities are now pretty well known to your Lordships. I'm just going to dip into various extracts just to make good my points. But I certainly wouldn't want to discourage your Lordships from reading these decisions more fully, particularly Mr. Justice McKenna's decision. At page 97, we see the introduction of the famous passage, which is often cited elsewhere. And at the bottom of the page, it then briefly expands upon what is meant by stages 1 and 2. But when one turns to page 516 of the report, 98 of the bundle, it's quite clear that Mr. Justice McKenna himself realised that stage 3 required further elucidation. You see that alongside B. The third and negative condition is, for my purpose, the important one, and which I shall try with the help of 5 examples to explain what I mean. And these examples are not meant to define what he means, they're meant to clarify what he means. And what I would suggest, that when one looks at those examples, there is a distinction between providing one's service and providing a service. Providing a service does not constitute an employment. It is, in the terminology of many of the cases, being in business on one's own account. Now, I don't have to put my case as highly as I am, but in the present case, what was the BBC purchasing? It was purchasing a brand. But as we'll see when we look at Lord Justice Nolan's judgment in Hall and Norma, you don't even need to sort of put it in those terms. But one could say the BBC was buying a brand. They're buying the public recognition, they're buying the reputation of Kaye Adams. But what these examples demonstrate is that there is an element of common sense to the exercise. It's all very well going through the binary questions of personal service, the mutuality of obligations that entails, and control. But at the end of the day, there is an element of common sense to the decision. What's the decision that has to be made? And that common sense requires a holistic approach to be taken. As Mr. Justice McKenna said, if I could just point very quickly to example number 4 alongside F, it talks about the main purpose of the contract. That's not something within the contractual terms, it is something external to the contract. Clearly it's related to the contract, but one is looking beyond the mere contractual terms. And at the top of page 99, third line, if the provisions of the contract as a whole, I accept what my learned friend will say about the provisions of the contract, but we are looking as a whole. And at the end of that paragraph, he may, in performing it, take into account other matters other than control, and I would submit other matters goes beyond the contract itself. And these submissions, I would say, are even clearer when one takes into account the analysis that follows of the preceding case law from around the common law world. On page, further down the page, we're looking at 517 of the report. We're looking at Australian cases. And there were 2 Australian cases, both from the same judge. And Mr. Justice McKenna makes it clear that he actually, if there's any dispute, he prefers the former over the latter. We're looking at the former. But just inside the quotation from that, alongside E, there is nothing to prevent a drover and his client forming the relationship of employee and employer. But whether they do so must depend on the facts. Not specifically the contract, but the facts. And later on in that passage, control, etc., cannot outweigh all the countervailing considerations which are found in the employment of him by servants of his own, the provision of horses, equipment, plant, rations, and a remuneration at a rate per head delivered. Now, none of those are actually inconsistent with an employment relationship, but at the end of the day, one is taking a holistic view.
But they were all specified in the written contract, as we see at D.
Indeed, but what I'm submitting is that the...
So when Mr. Justice Dixon used the expression the facts he was talking about were the facts to be found within the 4 corners of the written contract.
In that case, I accept that, but what I'm saying is that the submission goes wider, and we'll see that when we look at the economic reality of the situation. If we look at page 520 of the report, which is 102, towards the bottom of the page. My learned friend took you to the Canadian case and Lord Wright's opinion and about the ship owner. But what I would like to highlight is the last 3 lines of that page, because they make clear that if a man's activities have the character of a business, and then if the question is whether or not he's carrying the business for himself or other, then it tells you what considerations you take into account. But it already starts off with the question, well, if someone is actually carrying on a business, that in itself is a valid question to be asking and a factor to look at. And if I could then move on to the Silk case, which again my learned friend referred to, and that's alongside halfway down the next page. This is an American case. I would submit that the Silk analysis, now known as the business economic exercise, and we'll see that when we look at what was said in the question, I would submit that the economic reality test is the closest we have to ready-mix concrete stage 3. It is applying, at the question we have between D and E, are these men employees as a matter of economic reality? In other words, what Mr. Justice McKenna could have done was could have adopted the Silk approach, but ensured that at least on this side of the pond, we still have those 2 irreducible minima of personal service and control. But I would submit that what we have is you look at all the facts in the round. If I could ask my lords to turn also, my lord, to page 108 of the bundle, just a couple of further extracts. Alongside F, a man does not cease to run a business on his own account because he agrees to run it efficiently or to accept another's superintendence. And alongside G, we see that when analysing Mr. Silk's case, what Mr. Justice McKenna called Mr. Latimer's case, he used the terminology of Silk, referring to a small businessman. It is my submission, therefore, that the Hall and Lorem approach was not something newly invented by Mr. Justice Mummery and adopted by Lord Justice Nolan in the early 1990s. It lies at the heart of ready-mix itself. It was followed consistently for the quarter-century between the 2 cases, and as I already made clear, Hall and Lorimer and ready-mix concrete are clear bedfellows and have been ever since.
The small businessman quote is preceded by the judge saying a comparison of Latimer's profits with the wages earned by those who are admittedly the company's employees confirms the conclusion that he's a small businessman. But do we know from the previous part of the judgment whether the reference to Latimer's profits are profits on the particular contract with ready-mix concrete or profits more generally?
I believe they are from ready-mix concrete itself. As I said, ready-mix concrete had reset the bar for employment status in 1968, and the baton is then picked up the next year by Mr. Justice Cook in Market Investigations. I could just take your lordships very quickly to page 127 of the bundle. Just below A, and his lordship makes it clear that he is starting with the ready-mix concrete approach. He does not wish to, or even needs to, consider the earlier authorities. And I begin by pointing at, the passage I'm particularly relying on is between the middle of B and halfway between D and E. Beginning to point out, if I could ask your lordships to just turn to read that passage up to its self-decisive.
Where is it?
Halfway between D and E.
Oh, I see.
In short, what he's making clear is that he is dealing with stages 1 and 2 and will then move on to stage 3. We don't need to see the analysis of stages 1 and 2. We can pick that up at the top of the next page. And then we start getting to the passages where market investigations is regularly quoted. But if we start off alongside B, if control is not the decisive test, then what are the other considerations that are relevant? No comprehensive answers.
Yes, I've caught up. It's on the following page.
Sorry,
Thank you.
No comprehensive answer has been given to the question, but assistance can be found in a number of cases. And then we see along between G and H, part of the consideration is the person who has engaged himself to perform these services, performing them as a business on his own account. And then alongside H, this is the famous passage, no exhaustive answer has been compiled, and perhaps no exhaustive list can be compiled of the considerations which are relevant. So just pausing there, it would be a wrong for any court to say this consideration didn't get mentioned, or this one did. Ultimately, it's down for a fact-finding tribunal to consider what is relevant and to consider how much weight you give things. And I'm perfectly accept what my Lord Justice Peter Jackson said about lists having a magnetic effect. And one of the difficulties that, certainly in the tax tribunal, when employment status comes up, everyone says there's no exhaustive list, but they find themselves compelled to work through the items that were raised in ready-mix and market investigations, almost because they're afraid to miss something out. But it is simply what is relevant for a particular case. And one should not slavishly follow certain lists if they are not relevant for the facts of the case, or it should give them minimal weight. But even in this passage, we can see that we have this term, a business, someone carrying on business on his own account. If I could ask my lords to turn to page 129 of the bundle, it's just the next page. Just below B, I would say this is also particularly pertinent. The application of the general test may be easy in a case where the person who engages himself to perform the services does so in the course of an already established business of his own. But this factor is not decisive, and a person who engages himself to perform services for another may well be an independent contractor, even though he has not entered into a contract in the course of an existing business carried by him. In other words, to look at the current contracts, hypothetical contracts between Mr. Adams and the BBC, it's perfectly reasonable to take into account the fact of that existing wider business. It's not necessary to have that wider business, but it's certainly a highly relevant fact. And what Mr. Justice Cook is making clear is when you have no exhaustive list, and you can't have an exhaustive list, it is a multifarial exercise to be carried on. So the multifactorial approach establishing ready-mix concrete is firmly endorsed by market investigations the next year. If I can now take the court into the 1980s, and page 169 of the authorities bundle, we move on to the case of O'Kelly. And between G and H, we can see that the multifactorial approach is so beyond doubt that it is their common ground. If we look at page 186 of the bundle, we can see the application of that common ground between F and G, the paragraph in the present case, by Lord Justice Fox.
Sorry, where are we?
Page 186 of the bundle.
186, sorry.
I might have given you the wrong number. Page 121 of the report.
Page 186. Yes, sorry. And
So- Yes, that's Lord Justice Fox.
yes, whereabouts?
It's between F and G, the paragraph in the present case.
Yes.
It is not a numbered exercise. Different cases might be decided differently. As the last sentence goes, it was essentially a matter of fact for the Industrial Tribunal to decide which was correct after considering the evidence. But you don't just count the numbers and then simply see which one gets more votes. You have to take that step back and carry out some form of look at the picture, as Lord Justice Nolan or Mr. Justice Mummy later said. We can see this a further 3 pages down when we get to the judgment of the Master of the Rolls. Alongside B, the test to be applied in identifying whether the contract is one of employment or for services is a pure question of law, and so is its application to the facts. It's for the tribunal of fact not only to find those facts, but to assess them qualitatively and within limits which are indefinable in the extract. Those findings and that assessment will dictate the correct legal answer. In the familiar phrase, it's all a question of fact and degree.
Sorry, what are we getting at?
My Lord, I'm trying to emphasise that this is a question of taking a view.
I know, but what are they looking at here? I mean, I don't think there's any difficulty about that. The real difficulty is what you take into view in order to arrive at your evaluation. I don't think.
I would say
John's Master of the Rolls isn't quite right in what he says about it being a pure question of law, but I don't think that need detain us. But the real, I mean, that was the same with the passage from Lord Justice Fox. I couldn't see from that what he was looking at.
It's hard. It's indefinable. One has to look at the picture.
Definable. Sorry.
It has to be. Can I just take one step back and just say what? I would submit that the Master of the Rolls was correct when he says the test to be applied is a question of law.
All right. Yes. Okay. Yes. The test to be applied.
But ultimately, it's then a question of fact within the legal parameters. But what I would submit, and we will see this even further when we look at Hall and Lorimer, is that one has to look at the picture, take a step back.
I know, but what goes into the picture, that's
yes,
really, that's what really matters, and we don't get that from the extracts you've given us in O'Kelly.
Because each case will turn on its own facts.
No, but what in O'Kelly were they taking account of? Were they taking account just of the terms of the contracts, or were they taking account of external matters?
They looked at the fact that these waiters were working on short contracts with no guarantee of further work.
So that's a term of the contract.
It's a term of the contract. But nevertheless, they were able to conclude that even on those terms, the waiters were not employees, but were in business on their account as self-employed waiters.
Because they were looking, I mean, it was an analysis of the terms of engagement, including in particular each contract was very short term and there was no guarantee of any further.
Because there was no wider picture. It's not as if these waiters had
But we don't.
the growth
we
of the
don't
house.
know that.
Well, we do,
Anyway,
because
there we
actually
are.
we do know.
As far as O'Kelly is concerned.
We do know that because there is a finding that this was, in fact, their only work, and we'll see where the Master of the Rolls corrects the appeal tribunal for putting too much weight on that fact.
Yes, I see.
All right, but we're still a bit unclear as to what your submission is as to where the frame is. So, as I understand it, it's common ground between you and Mr. Tolley that one takes into account all the terms of the contract.
Of course.
That's obvious. Secondly, I understand it to be common ground between you and Mr. Tolley that you take into account those facts which are known to both of the contracting parties as at the date of entering into the contract. So what divides you, as I understand it, is whether it is also legitimate to take into account facts which are only known to one party.
Indeed.
You submit that is legitimate.
Indeed.
Mr. Tolley says it's not legitimate.
Indeed.
So therefore, what we're looking for in the authorities is something that answers that question. Is it legitimate to take into account facts known to only one party? And where in O'Kelly do we find any assistance on that?
You won't, my lord.
Right, thank you.
The clearest authority is Hall and Lorimer on that point. It's the whole picture.
But where do they say in Hall and Lorimer? We will come to it.
Yep, we will.
But where do they say it's legitimate to take into account facts known to only one party?
The facts of that case involve someone with multiple clients. And the underlying assumption is client one will have very little detail of the relationship between Mr. Lorimer and client 2, client 3, client 20. Nevertheless, what we see, both at the Commissioner, High Court, and this court level, that the wider picture of him carrying on a business as a freelance vision mixer was what answered the question.
But how was that a fact known to only one party? Because if you have a situation where at the date of the formation of the contract, it's known to both parties that one of them is in business as a freelance vision mixer, that's a fact that's known to both of them.
But then, if one takes it at that approach, that's the answer in this case, where the fact that Ms. Adams is carrying on a business as a freelance journalist is known to both parties. That's the answer. But one can't just
But
simply...
then you need to point to a finding of fact by the FTT in the present case, based on the evidence, that that was indeed a fact known to both parties. I mean, and it's not clear to me, actually, whether they found that or not. So maybe you want to... We do have those points I highlighted yesterday, paragraph 6, I think it is, in the First-tier Tribunal decision. So we don't precisely know what the BBC knew, but it was... That's the critical question.
Indeed, but it was obvious. They were buying the brand. The reason they wanted...
How does buying the brand help? Because you can buy the brand even if you want to employ someone.
I accept that. A football manager would probably be a good example.
Indeed. Thank you. A good example. I agree with that.
I'm glad I'm getting somewhere with my lord.
Can you just situate this interesting debate in why it matters in this case for the outcome? What is? I mean, I can see that the precise terms of the loose women contracts and so forth may not have very well no evidence that they were known at all to both parties. But I mean, why does it particularly matter to you that you establish this point about facts known to one party only?
I'm trying to establish the point because it's being put against me that the only factors that can go into the frame are points known to both parties. And
Right, so what is the particular fact that if you could, as it were, preserve it, what is the fact that you're seeking to preserve and put into the frame?
The existing business.
Well, yes, but that's such a vague
Exactly,
statement.
exactly.
What aspect of the existing business is it that you're anxious to?
The fact that Ms. Adams is carrying on a business on her own account, at least in the hypothetical world, as a freelance journalist, and that this engagement is very much an engagement within that.
I'm still not seeing what it is that's known only to Miss Adams. If we take it like that. I mean, of course,
okay.
the BBC knew who Miss Adams was and the sort of stuff that she did and her profile, and no doubt all of these things were what led it to want to contract with her. But what is it that might fall foul, might on Mr. Tolley's case fall outside the frame that is so important to you to get into it? Give me an example of a fact.
The first fact that comes to my mind, my lord, is actually a fact which my learned friend is trying to use against us, and that is the percentage of income in a particular year, the financial dependency. Where no one is going to know. The other side is not going to know what the denominator is. And in fact, the parties aren't even going to know until the end of the relevant accounting period.
Right, so it's only the taxman that knows this.
And the accountant at the end of the day.
At the end of the day.
But what I'm saying is that the question of employment status, we're saying the frame is so wide, it's for the fact-find tribunal to decide what's relevant.
Right, so this raises an interesting question then. The 50%, 70%, 90%, 98.5% and so forth, these are all figures that come after.
Absolutely.
They're not matters that are in the parties' express minds when they're making the contract. However, by employing Mr. Hawksby for 220 shows or Miss Adams for 160 shows.
Yes.
The
Engaged.
BBC,
Can I use the word engaged so there's no...
So I meant the same.
Yes.
By using. Then the BBC will have had a shrewd idea of the extent to which they were or weren't dependent on that work, won't they?
Well, I would...
As a broad matter, they don't have to have the precise percentage figures.
Well, I would submit, certainly in Ms. Adams' case, 160 days is less than half the year.
Yeah, well, exactly.
We're talking about 3 hours...
Meaning that itself tells you something.
It's less than half a year, with for less than half a working day, where we know that Ms. Adams spends between 12
That's
and 2
right.
hours. She has...
But these are not covert facts.
They're not covert.
This is, as you make an appeal to common sense, it's common sense that obviously Ms. Adams is and can do other things at other times, and provided they don't run up against what the BBC thinks is important, it's not going to be a problem. So I still just one last time want to find out what is this tremendous one-sided fact that it's important to you to be able to bring into play, or is this really just an argument about nothing?
Perhaps it is. And my lord, I will try to come back to you in case there's further thoughts from those behind me. But the way I ran the case below, because this question of the status of Hall Alarm didn't come up below.
No.
So it's sort of newly arising now. But the way I ran the case below, so I was only in the Upper Tribunal, and the way this case has been run this year in this court is that common sense tells us this was an incident of the existing trade. Now, that has potentially led us to saying, well, that could be either sort of you're answering the question before you've even started, or you're sort of bringing in facts from outside. You know, the way I have pitched the case, and I believe, and I submit that is the correct way to pitch the case, is we take a step back. It is absolutely obvious that this is part of the...
So you don't accept that you're bringing in facts from outside, as you put it, there are no facts from outside that you're identifying that are known only to you. They're all matters that would have been obvious to both contracting
yet.
parties.
I hear no dissent from those behind me at this stage.
Well, that's very helpful, because that may reduce the scope of our inquiry. But it leads on to this, because you pitch it, as you put it, on the common sense basis that you say you've just articulated. And I'm grateful to you for making it so clear. But how do you square that with your acceptance yesterday that you can have self-employment and employment in parallel? Because if once you accept that, then the fact that there's a pre-existing business of self-employment tells you nothing. You have to look at the instant contract, don't you?
You have to look at the instant contract, but look at the wider picture. I do not. You look at the issues, the similarity of the services, the complementary nature of the services, your relationship. It all turns on a question of fact. And I would actually submit that the best example of how things can be so concerned.
Well, I'm sorry to interrupt you.
Of course.
Again, I'm not quite clear where you're going. Again, let's try and focus on what the difference is, if any, between you and Mr. Tolley. I don't understand Mr. Tolley to dispute that if it's known to the BBC in our case that there's an existing freelance business, that's relevant. So he's not saying that that's an irrelevant consideration.
That's helpful.
But you appear to be saying it's determinative. And
No, I'm certainly not saying it's determinative.
Right. So you add idem that it is relevant,
yes,
but not determinative.
absolutely not determinative. It can't be determinative.
Right.
Because
So doesn't that then drive you to consideration of the particular contract?
Nevertheless, the particular contract has to be considered in the context of those wider activities. And what I was going to suggest, and I hope will permit me, the fallen hitching case is indeed one of those cases where the coin can fall both ways. And I would submit it did fall both ways. The commissioners, I would submit not wrongly, considered the engagement with Sadler's Wells, albeit at the beginning of the dancer's career, as an incident of the profession. The Vice-Chancellor looked at it a different way. And I would submit both approaches are right, because ultimately it's a question of fact, and different judges are going to weigh things up differently. My only challenge with what the Vice-Chancellor did is that he didn't actually consider, was this a question of fact and was I entitled to intervene? I would, with respect, submit that he actually reached his own decision and then highlighted the inconsistencies with the Commissioner's decision. But that was clearly a case where there were no other engagements. So the picture had fewer details. If I, as a self-employed barrister, were to spend, and many junior barristers do this, spend a few weeks at local authority on a secondment, covering someone on sick leave or maternity leave, and they be told you'll be paid £300 a day or whatever the rate is, and deal with all legal questions that come in between the hours of 9 and 5. Now, in many ways, the work they do will be no different from an employed solicitor, even one on a short-term employment contract. But I would submit that the context of engaging a barrister who is carrying on a self-employment in his or her own right does shade it and is a relevant consideration, that even on precisely the same terms, and in practice there are going to be differences because of pension rights, etc. But if one strips out all benefits, strips out all statutory rules, the mere engagement of someone can have different outcomes depending on the picture. And I would guess O'Kelly is a further example of that.
I mean, speaking entirely for myself, I find your secondment example very difficult. But why don't you go back to the example you gave yesterday of the barrister who's engaged in a long planning inquiry? So it's not, I mean, he's engaged or she's engaged for the planning inquiry rather than all legal issues that come in between 9 and 5.
Yes.
How do you develop your argument in relation to the planning inquiry barrister?
Well, the bullet point submission is that engagement, however long it lasts, is an incident in the professional activities of the barrister.
And you would say that looking at the terms of his retainer, or her retainer, for that inquiry is not enough?
No, because one has to look at the whole picture.
Well, I think that there may be some limited overlap between you and Mr. Tolley on this issue, with you saying it can be frightfully important and him saying it may be relevant, but it will almost always be of nil or minimal importance. So you may have coalesced that there is a possibility of relevance, but you seem to me at the moment at least to disagree about what the likely relevance is in any particular circumstance.
My Lord, I think what I would make is the point that I've already alluded to it, is that when one looks at the cases, it's those cases where there is a multiplicity of other activity that Hall and Lorimer gets put into the headlights. And as I said, Matthews is an example where the revenue were more than happy to deploy it because they were trying to show that it was a self-employment, not an employment. The other point I'd just like to make at this stage, just to pick up on what I said a little earlier, we have to remember that the contract, we're talking about individual engagements with Ms. Adams, between Ms. Adams and the BBC. Yes, they were for a number of programmes and the contracts would last for a year, but we're not talking about a long, one long contract changing. We are talking about discrete engagements, roughly for a year at a time. So that in itself is part of the picture, and we'll see shortly that my learned friend has made reference to it briefly already, the Windle case, which makes it clear that the number of engagements, the non-guarantee of any future work at the end of each engagement is a relevant consideration. Given what Lords have asked, it might be that some of the authorities I come to will say, move on, Mr. Gordon, because, but nevertheless, I would just like to sort of allude to them because they do reinforce the idea that one does look at the whole picture. And I would submit that some of the passages will identify matters, certainly outside the contract. We can look in due course as to whether they would be known to the parties. The authority I'd like to take your Lordship to next is the Privy Council's decision in Leeting Sang. It was a case where...
Give us the page reference.
I've got 225, but I think I'm going to make a brief reference to the headnote or the list of authorities, so I just want to make sure that doesn't take you too far, but I just want to make it clear to your Lordships that this was a case where the Lordships had heard submissions on ready-mix concrete, but they started their analysis with market investigations. Because, as I've already submitted, market investigations is simply an application of ready-mix concrete, stage 3. And then we have, alongside C, the question to be answered by applying English common law standards to determine whether the workman was working as an employee or as an independent contractor. What then is the standard to apply? This has proved to be a most elusive question, and despite a plethora of authority, the courts have not been able to devise a single test that will conclusively point to the distinction in all cases. The Lordships will agree with the Court of Appeal when they say the matter has never been put better than by Mr. Justice Cook in Market Investigations, and then we have the passage which we have already looked at. If I could ask my lords to turn further 2 pages, to page 227 of the bundle. The point I was going to make was alongside F and G, starting whether or not going up to a trial court just alongside G. But I'm not sure that's specifically relevant for the discussion now, although it is a point that is relevant when we look at the auto claims point in due course. So as we're there, your Lordships might just wish to.
So where is it? Sorry.
Alongside, just above F, the paragraph beginning whether or not, and then halfway down that paragraph to just beside G by the trial court.
Yeah, but what they made clear is that in that case there wasn't a written contract, and therefore necessarily you had to find facts as to the
Indeed.
relationship between the parties.
But as I will take the court to in due course when we go via Carmichael and then particularly auto claims itself, the written terms are not determinative. But we'll make those. I'll make those submissions in due course. What I'd like to do now, my lords, is to take you to Hall and Lorimer itself, and to take you to Mr. Justice Mummery's judgment, because it is quite clear, even if these passages were not fully cited by Lord Justice Nolan, but it was quite clear that Mr. Justice Mummery had ready-mixed concrete in mind. We can see that alongside H at the bottom of 244. There is a broad measure of agreement, that paragraph, and reference to ready-mixed concrete market investigations and Leating Sound. And halfway down that passage alongside J, the question has never been put than by Cook J in the market investigations. The question is, does the taxpayer perform his services as a person in business on his own account? So applying that to the present case, is Ms. Adams providing her services as a person providing her as a freelance journalist? And I would say the answer is self-evidently yes.
But, I mean, so stated, is it not simply the obverse of the question, does the taxpayer perform his services as an employee? It's either one or the other.
Indeed, but the as, it all turns on the as. What is the context in which these services are being performed?
I'm not sure it does there. I mean, I think it may elsewhere, but you could simply ask, well, looking at the contract, is the taxpayer performing services as a person in business on his own account or as an employee? It may be other parts of Hall and Lorimer which bring into the picture I forget whether it's Mr. Hall or Mr. Lorimer's.
Mr. Hall was a tax inspector.
Mr. Lorimer is the taxpayer. Mr. Lorimer's business as a vision mixer.
The way I learnt it, my lord, was the person who loses in the commissioners.
Yes, is the taxpayer.
No, the person who loses, the person who loses the commissioners.
I meant they were the appellant.
Is the appellant in the High Court, and certainly
some people say it, but they normally say it in the Court of Appeal. Anyway, that's my point. Just that particular passage doesn't, I think, take.
No, I agree, but
it's more where I think you need to show us where Mr. Justice Mummery brings in the Mr. Lorimer's more general point.
It's the next 5 lines, my lord.
Okay.
If he does, his work as a vision mixer for the various television production companies must be regarded as performed under a series of contracts for services entered into by him in the course of carrying on his own business. If he does not, his work must be regarded as performed under a series of...
I mean, it does seem to me that this is all totally tautologous. I mean, well...
My lord, I could... I could rather glibly respond that when one is trying to state the obvious, once one puts more than 5 words to it, it becomes tautologous. That's why it's a question of fact for the fact-finding tribunal, whether it's the employment tribunal,
It's almost like saying the question is he an employee or not?
Yes. Yeah,
we know that's the question. The extent to which this formulation actually is a helpful test.
What it does, it just shows that the difficulty of a precise formulation.
Yes, but I think the point in Hall and Lorimer is Mr. Lorimer was he was doing vision mixing work for a lot of different companies, 20, I think.
Yes.
So. And I mean, those words that I picked you up on, like my lord, I think it of themselves doesn't tell you anything. But my understanding is in this case that Mr. Justice Mummery did have regard to the sort of generality of Mr. Lorimer's work. I mean, so over the page 612, the first full paragraph, in order to decide whether a person carries on business on his own account, it is necessary to consider many different aspects of that person's work activity.
Exactly. Well, that's
I know what I was trying to.
Well, that's that's the important bit.
That's the important bit which we were coming to.
Oh, well, right. Sorry.
No, I'm more than happy for you to advance my arguments for me, my lord. But rather than sort of jumping backwards and forwards, I was trying to work my way through chronologically. Right. But and that's where and this is indeed that passage which is the most famous bit. It is not the mechanic. Now, I was almost going to not highlight too much of this passage because we're going to see it in the Court of Appeal.
Yeah.
But it is a case of
taking
that step back and
because different
yes.
What is in the picture?
What is in the picture?
However far from the picture you stand.
And that, so sorry to sound like a broken record, but that's a question of fact for the fact-finding tribunal. But usually it will be obvious what is relevant at the time when the question is being asked. And I would, for the avoidance of doubt, I submit there is no difference in principle between 20 clients with jobs of between 1 and 20 days in duration, the facts of Mr. Lorimer, and different engagements in the freelance journalism world, including one where 160 calls on one's time over the course of a year.
But do you seek to get from the first full paragraph on this page?
Yes.
The fact that it's not consistent with a statement that you're bound by the 4 corners of the contract. That the whole picture approach is not consistent with a look at the contract.
And only the contract.
And only the contract.
Absolutely.
And that although the second or third full paragraph, which is the other sidebarred paragraph on that page, was not expressly endorsed, it's no more than a working out of the first.
Absolutely. Lord Justice Nolan, with respect, would not have endorsed one passage had he disagreed with, and said nothing more had he not, if he disagreed with what followed in the analysis.
I presume you would accept that all of this has to be viewed in the context of the facts of the case, which are helpfully summarised by Miss Justice Mummery at 243 in the bundle, starting at the top of the page, particularly at B, where he explains about building up a list of 22 companies. The number on the list remained about 20. Some original names stayed on this, new names were added, and so on. And then he explains about what happens when bookings clash. He would send a substitute, and then at E we find its bookings 1 to 2 days, first come, first served basis. So it would seem pretty clear from this that the people he was contracting with knew about his other work, because that was the whole scenario, was that he was offering his services. You know, it was the CV that he had, like so many CVs, had a list of his clients.
My lord, I would say, obviously, each case turns on its own facts. Obviously, Mr. Justice Mummery had the facts of that case in mind, but I would also submit that these facts are not a million miles from the present case. When Ms. Adams wanted, now this is where there's a problem when one looks at the contract as set down by the Upper Tribunal, that's set in the First-tier Tribunal, but as a matter of fact, Ms. Adams gets a call, could you do loose women next Wednesday? She'll tell the BBC, I'm not doing it, someone else will. The programme will be presented by someone else, or have the same name. But practically, they are, the only difference is that there is a set commitment of 160 days under the Upper Tribunal's version of the contract. But that's just a mere consequence of the business in which Ms. Adams is working. The vision mixing, no one's going to want to commit for such a long period because that's the nature of the job. Going back to the West End stage, someone wants to be engaged for 12 months run. That's not unusual. It's just the nature of the business. The theatre needs to sell the tickets with a big name on the billing. So I would submit that that's why Hall and Lorimer is so pertinent to this case, because it is so similar. My laws have now probably preempted me on 612. Actually, I could ask you to turn to 612E, which is the beginning of the passage that is not expressly cited.
Yeah, and Mr. Tolley has taken us to this.
Indeed. But we do have a number of factors, and I would say some of them are clearly outside the scope of the contract itself. And obviously we know it's not a complete exhaustive list. Between F and G, it may be relevant to consider the understanding or intentions of the parties, not necessarily contractually binding, whether the person performing the service has set up a business-like organisation of his own. Well, it's a potential consideration. Does having a website, does having a CV of one's clients, does having an entry on an internet media database, what amounts to having the business-like organisation, having the list of one's prior work known? How many engagements he performs alongside G is a fact. Is that a question within the contract, or is that looking elsewhere, whether they perform mainly for one person or a number of different people? Some of those facts will not be known by the engager. They'll know there might be more than one. They won't necessarily know how many. The BBC, as a matter of contract, is not going to know of every corporate do tended by Ms. Adams. When she excuses herself from loose women to attend a corporate do, yes, they will know about it. But it's not going to be a necessary part of their knowledge in all cases. So what we're saying is that what Mr. Justice Mummery is doing is explaining the principle that is clearly consistent with ready-mix concrete at stage 3. And then when we move to the Court of Appeal, if I can ask your Lordships to turn to page 249, just to note that the lordships had ready-mix concrete refer to them, it's in the list there. What I emphasise is that the court was urged by Mr. Goldsmith, as he then was, to apply a checklist approach. That was an approach that Lord Justice Nolan was very, very reluctant to engage with. He did as a sort of supplementary approach, but at the end of the day, what this court held is that it has to be that holistic approach derived looking at a wide range of factors.
What do you say about the passage relied upon by Mr. Tolley at 218, where Lord Justice Nolan said the question of whether an individual is in business on his own account, though often helpful, may be of little assistance in the case of one carrying on a professional vocation, and gives the example of an actor or a singer?
My lord, there's a very straightforward answer to that. That when the cases have talked about, does this person have a business structure, that should not be elevated to a necessary test, because that kind of question is going to be rarely relevant for someone providing their professional services. It's not saying that in the professional field you can ignore all these cases. It's the opposite. It's saying don't be too rigidly bound to looking at trappings of business. It's looking at whether or not you have to take a picture, look around. The trappings of business kind of exercise, whilst helpful in many cases, could lead you astray if you're looking for something that's not going to exist. And in the case of the professional provider, particularly in the creative arts, it's what is clearly a self-employment will have little in the way of, wouldn't have the business premises, if I can use the slightly old-fashioned terminology, one which would have been perfectly applicable in 1994. Obviously, different people in different creative arts will have an agent. Ms. Adams did have an agent, part of the trapping business. I know that some employees have agents, particularly, again, in the football world, but I would suggest that's more of the exception. But the point is, even a self-employed, I rely very much on the self-employed author alongside the your lordship got that part of the passage. But I would submit that to use this phraseology as a warning, don't get bogged down with someone running a business on their account, I would suggest you'd be led astray. Can I ask your lordships to just turn back one page to the bottom of page 217, a paragraph alongside H. I would submit from this passage that one shouldn't spend too long looking for product. It is sufficient that one finds that there is a service that has been provided. And that's particularly clear when one continues on to the top of page 218 when we look at the surgeon and the barrister. So at this stage, with having looked at Hall norma, what I maintain is that Hall norma shows that the picture, the frame, goes wider than the contract. It reinforces the idea that there is no one test that fits all cases.
In the great majority of cases, where there is a contract,
But there's always has to be, my lord, there's always got to be a contract.
a written contract,
A written contract, yes.
will the contents of the written contract not, in a sense, reflect a great deal of information about the surrounding circumstances, so that by looking at the contract, one is likely to get most of what one needs?
There will be definite clues, but I don't want to push that too far, because we've got very clear authority from ready-mix concrete going through to Dragonfly, and also Lord Denning in a Massey case, which I don't think you've been taken to, but you have been. It's been alluded to, that how the parties define themselves in the contract is non-determined.
I understand that, but assuming the contract to be a good faith document.
Good faith or legally accurate.
Well, yes, I mean, you may or may not want to do it with reference to your contract, but would looking at the terms of the contract and seeing what is and what isn't allowed and what is excluded and what is demanded and so forth, would that not tend, in the majority of cases, to shed a great deal of backwards light on the circumstances, so that the idea that one would have to go looking elsewhere to get some basic idea of the setup might be more imagined than real?
My lord, I would like to say yes, but I'm hesitant to lay that down as a...
No, I'm not saying as a test. I'm just saying that it may be this case, I don't know whether it's correct or not, if one looks at the contract analytically, one would be able to deduce a great deal about the activities of both parties.
Absolutely. And
maybe not only a great deal, but one might be able to deduce quite enough.
And the examples which immediately spring to mind are the fact that the word freelance is scrawled all over the contract.
Well, that you would approach maybe wearing gloves, but
nevertheless, it shows it is not totally irrelevant.
No, but
It's
more
not
the fact that it's for a certain period of time, that it refers to other activities by one of the contracting parties,
indeed,
and so on and so forth. So I'm again just wondering, at least for the purposes of your case, how, and I know you're trying to help us about the frame,
yes,
but whether in fact there's any lively issue in practice about where the frame was drawn. Even if one looked at the contract themselves, you would still be able to make the points you're making.
I can make the points I'm making, but the problem is the key pointers that I would take from the contract itself will all be countered with they are so weak or marginal to be of no real significance. And that's the problem. So I will happily advance, I'll address the point by saying it's a fixed fee for a certain finite number of engagements. No commitment to renew, or even promise, as I said yesterday, no undertaking even to renegotiate on good faith. I have to admit that none of those facts are inconsistent with an employment contract, but they do colour what's happening. The fixed fee makes no provision for statutory benefits, pension contributions, etc. Again, statute would often intervene if there were a real employment contract, but nevertheless, with an engager such as the BBC, one might be able to say, well, this is not the BBC trying to pull a fast one. This is the BBC trying to keep this within self-employment realm.
Yeah, you've got to be a bit careful about that, given the history with the BBC.
My lord, the limit part of the argument I ran below was the argument of redeployment. And at that point, the key case that had been heard in the Upper Tribunal was the Krista Ackroyd case. And also a BBC contract. Now, the BBC, that was a contract, superficially a similar case, but one where Ms. Ackroyd was engaged for a 7-year term, which I would suggest raises some eyebrows, and could also be deployed on anything that the BBC wanted. The contracts expressly said anything that the BBC wants, we can ask you to do. So they could get her to present Strictly, or the weather, or the programme that she was actually engaged to present. And they had more control as to where she conducted it. Whereas this is for a fixed task, multiplied by n, the number of engagements. So there are definitely pointers within the contract, but I don't want to say they get us home and dry. They ought to, but what reinforces the point is the wider picture. On what basis was Ms. Adams engaged? Why was she engaged? Who was she? The practice, even if it was concession by the BBC, to allow other engagements which raised Ms. Adams' profile or kept it high, were very much accommodated by the BBC.
Right, so in short, do you need this? No, but it helps.
I'll try to do the next couple of cases without taking to it, just give you the reference. The case of McMeechan at 555C, so 266 of the bundle, endorsed what was said in O'Kelly. And you will remember last week, in the Kickabout appeal, it was suggested that McMeechan should be no longer relied upon because of what was then said by Mr. Justice Buckley in Montgomery. But I'd just like to qualify, to make clear where the disagreement was. And Mr. Tolley did actually make reference to it yesterday. The apparent error in McMeechan was not the application of stage 3 of ready-mix concrete, but the suggestion that he might have jumped straight to stage 3 and didn't actually consider stages 1 and 2. And we can see that at paragraph 28 of Montgomery, page 296 of the bundle. But whilst I'm also looking at Montgomery, if I could just ask you then to turn to page 294, bottom of the page. Just some of the terminology that has been used to describe this. And it doesn't necessarily take the case any further, but it just puts yet more colour in it. As several cases of recent, 3 lines from the bottom, as several cases have illustrated, it directs tribunals to consider the whole picture.
Which page?
So, page 294 of the bundle, my lord.
294. Yes.
So, just to reinforce, it's the whole picture, emphasising that stages 1 and 2 cannot be jumped as stages. But then there's also additional terminology, which is just for your lordship's interest, 6 lines down from the top of the next page. We now talk about the melting pot. But the question which will then come back to me is, well, what goes into the melting pot? But nevertheless, there is this general picture. My lords, if I could ask you to turn to page 343 of the bundle, please. This is one of those IR35 cases my learned friend referred you to yesterday. And my learned friend referred you to paragraph 19
Give the reference again.
Page 343.
340, sorry.
Sorry if I was unclear.
No. Thank you. Snapped.
Indeed. And my lord, were referred to paragraph 19. But I would just ask, I think Sir David Richards did actually make reference to paragraph 20, but I certainly want to emphasise paragraph 20. It's just yet further authority that the fact that one was in business is no doubt an important consideration or contextual circumstance. Obviously, it's not the beginning and end of it as the paragraph continues, but nevertheless, I would submit that it is a relevant factor. I'd like to move on to Kaye, and I've heard different people pronounce her name in different ways, so I have no knowledge, but unless I'm told otherwise, I'll go with Kaye. Page 479. Because having now analysed the history, I would suggest that what was said by Lord Justice Elias then makes a lot more sense. And in paragraph 6,
Sorry, reference again, please.
479 of the bundle. And we can see what has... Is this suggesting any irrelevance of Hall and Lorimer? I would suggest not. What it's saying is what I said yesterday afternoon. There was the control test in Victorian times. The middle of the 20th century, feeling uncomfortable and putting the water with different tests. We have the American test, Silk reference, to the business or economic reality test. And then we get the multiple or the multifactorial test. And if we look at the parenthetical note at the end of paragraph 6, involving analysis of many different features of the relationship. And I would say features includes its context, wider context. So this is not in any way a suggestion that Hall and Lorimer should be relegated as of minimal relevance. At the end of paragraph 8, the approach recognises the issue is not simply one of control and nature of contractual provisions may be inconsistent. When applying this test, the Court of Tribunals is required to examine and assess all relevant factors. Obviously, the question then comes, well, what's relevant? And I have to accept that. To examine which make up the employment relationship in order to determine the nature of the contract. But again, I would emphasise that it's that wider context, as we have seen in other cases. And I would submit that I'll just bring to your Lordship's attention at paragraph 14, where Lord Justice Elias repeats his reliance on ready-mix concrete, saying there's more than just control, but then also brings in O'Kelly as another example. I'm not sure whether your Lordships need to be taken to it expressly, but at page 489 in White and Troutbeck, we have the reference to a wide range of factors, but I again accept that we have the point that how wide is wide.
That it's what?
There's always the retort, how wide is wide?
Yeah. Yeah.
But it's certainly not suggesting a narrow.
Right, so by now, we're getting the message that if these courts had wanted to say, stick to the contract,
There's been
plenty of opportunities.
Indeed. My Lord, you've now been taken to varnish. Is there anything else I can assist you as far as varnish is concerned? There are references to overall picture, whole picture, and as I said earlier today, it's showing that Hall and Armour is live and kicking in the employment tribunals.
Have you, is Harvey the leading textbook on this area?
I looked at Harvey, and it's, as a tax practitioner, where employment law, the most relevant point of employment law is status. Harvey devotes extremely little space to this question.
I see.
I think the statement I would make, which would probably could be supported by a reading of what Mr. Justice Briggs said in Weight Watchers, but could also be, I don't know whether it predates that there might be a tendency of the courts to favour employment over self-employment when given any case. It was whether that is a justified statement. But there are about a couple of pages in Harvey. But at the end of the day, they say the law is, these are the leading cases, it's down to the facts. I haven't looked more widely.
I wonder just for completeness whether you could let us have those couple of pages.
I'm sure.
In due course. Thank you.
And if it turns out to be 3 rather than 2, I hope that my couple will be treated with a...
We'll assume that after 2 you lost interest. Right?
Indeed. At this point, what I'd just like to do is just refer your lordship to 2 further authorities. I would say that the Supreme Court in Uber gives us yet further reinforcement.
This is on the same.
Yeah, we're still on the point. Uber. It's page 1035 of the bundle.
Paragraph?
It's the closing part of paragraph 91.
Thank you very much. At letter E.
Indeed.
1035.
But it does need a slight explanation.
Right. Shall we just read that paragraph
Indeed.
and then you can explain it?
This is, sorry, paragraph...
Is I agree subject only to the qualification there.
91.
Oh, there we are, yes.
Yes?
What we see in Uber, by reference to the Court of Appeal in Windle, is a relevant factor, is the intermittency. The fact that once this contract expires, there's no guarantee of further work.
This is all about whether someone has worker status within EU law. How does that help us?
I should explain, my lord. That was the context in which Uber was decided. But the reference to Windle was actually straightforward employment status. And what, when we look at what Lord Justice Underhill had said in Windle, we'll see that actually...
Well, so Windle may help you, but Uber doesn't, because as we can see at E, Lord Legate is specifically concerned with worker status.
But I would say that if the principle applies to worker status, then it must, a fortiori, apply to employment status. Because worker status is even wider than employee. If one remembers how the definition of worker works, the classic definition is in section 230 of the Employment Rights Act. The worker, there are technically 2 limbs to being a worker. One is being an employee, which is the question that this court has been addressing in the last 2 days. But then there's the limb B, which is a category of the self-employed who have certain features of an employment relationship but don't have complete employment relationship.
All right. Well, we're getting out on a twig here, aren't we?
Well, indeed. But I just wanted to, I need you to clarify, because obviously Lord Justice Arnold has correctly lighted upon the fact that it refers to work and unwanted. But if we look at what Lord Justice Underhill had said on page 1066, he's cited by Lady Justice Elizabeth Lang in the recent PG Mole case at the bottom of the page. And we actually have the quote 4 lines up from the bottom of the page.
This is all about mutuality of obligation, and we know that that's a key ingredient on the RMC test because it's stage 1.
Indeed, my lord, but what is important is that the lack of continuation of work, the intermittency of any work, the fact that there is no guarantee of any work coming up, each engagement is an engagement on its own, stands on its own, that is nevertheless a relevant factor to take into account. Obviously, no factor is going to be determinative, but the mere intermittency is a relevant consideration when looking at stage 3. That's clearly what Lord Justice Underhill is saying.
But I'm sorry, I'm baffled. How does this help us? Because the issue in Windle, as we can see from the quote, was again worker status. And the question was whether there was any overarching agreement. So you had these interpreters doing assignments,
Yes.
on a periodic basis. And the question was there an overarching contract? Answer, no, there wasn't, because there was no obligation to provide the work and no obligation to accept the work. Therefore, no mutuality of obligation. But if you translate that into our context, that's all about stage 1 of RMC. How does it help us with the question about stage 3?
My lord, because it also sheds colour on your relationship, of the status of the relationship within an assignment. And one of the mismatches between the employment tribunal cases and the tax cases is that the revenue are concerned only when money is being paid, i.e. when one's actually engaged. A lot of the employment contract, a lot of the ET cases were trying to find continuation because of the requirement to have 1 year or 2 years continuous work under the term as that is defined in the ERA. But within the actual performance of a particular assignment, your status, even in that sense, which is particularly pertinent for tax purposes, will depend on all the facts, including whether or not this is a fixed short-term engagement with no right of renewal. And then finally, the last authority, well, actually is now PG Mod itself. If I could ask your lordships to turn back to 1060. Our supplementary skeletons have probably made reference to all these anyway, so I don't think I need to explain.
So what's the point about Pigeonhole then for your purposes?
It's just further reinforcement of the idea that a particular engagement cannot be decided by rule of thumb. That's paragraph 55 of PG Mole. And there's also a passage at paragraph 119. I think it's cited in our skeleton arguments anyway.
55 and
119, my lord.
paragraph 119.
The phrase is, look at all the circumstances in the round. So, my lords, what I will say is that ever since the seminal case of ready-mix concrete more than 50 years ago, there has been a consistent line of authorities taken by the appellate court that the third stage involves a multifactorial approach. All surrounding facts are potentially relevant. There is no single checklist. The provenance of this multifactorial approach is ready-mix concrete itself, but it's been repeatedly endorsed at this level and in the Privy Council. Hall and Lorimer is far from an isolated incident of a multifactorial approach being laid down. It is instead a correct statement of the law, entirely consistent with and a logical corollary to ready-mix concrete. Being a business on one's account is generally a label to providing services otherwise as an employee, but obviously can, in the right circumstances, in Hall and Lorimer in the present case, be the existence of an existing business is a relevant factor to take into account. When it's taking a step back and looking at the overall picture, that is the correct approach to follow in all cases, unless ready-mix concrete proves to be determinative. I therefore submit that these authorities show that you go beyond the terms of the contract under consideration. If we are just looking at the facts known to the BBC on this case, and I'm not saying we should limit that our focus to that, but even if we did, they were buying the Kaye Adams brand.
You said that once before.
I have. Maybe I preempted myself.
Is that what the FTT found? I mean, I would have thought they were engaging her services. I mean, just her brand seems rather to
The reason they
understate.
the reason they bought, the reason they engaged Ms. Adams, the reason they paid her what they paid her, the reason they gave her the flexibility that they gave her, was because of what her name would give their program.
And where's the finding of
It express finding, no, it's in the evidence, the notes.
that? Well, that's
Yes. The reason this is difficult because I'm on this appeal. We're focusing on
where'd you get to from that? I mean, say what if it's bought if Ms. Adams is
It's a
as a
relevant
brand? How does that help?
It's a relevant consideration. Are they?
Well, the trouble is that you've got no finding.
No, but I would say it was implicit in their.
Well, did the FTT say, well, this is a relevant consideration?
I don't believe there's an express finding one way or the
They
other.
didn't refer to it.
No.
Well, then,
Other than the fact, well, they do refer to the fact that when
presumably she's a very good presenter. I mean,
Yes.
That goes a lot further than being a brand. I mean, just because she's well known, well, that means no doubt she can charge more money. But
she was a good.
I just find this a slightly odd concept that you're buying a brand. I mean, there are lots of very well-known radio and television presenters, but they're not a brand. They're very good at their job.
But they hadn't been on Loose Women, and it was Loose Women.
Well, they may be.
My lord,
Okay.
your knowledge of Loose Women as a television program is probably.
I'm not getting
limited
into
to
that at all. I'm not giving evidence of this area.
No, but no, I wasn't suggesting you were. But what I'm suggesting is that for
Well, look, I think,
producer-
all right, you've told us that there's nothing in the FTT decision about it.
other than the fact that
If you want to point
I think-
to something which makes this point, but Mr. Gordon, I don't think you can just pluck it out of
No.
what you tell us was the evidence. We're not looking at evidence.
all I will say is that refer to what I opened with is the paragraph 6 of the first tier's decision, and also what Mr. Patterson, HMRC's own witness, how he described.
Paragraph.
50, I think it was 57. It was within the summary of the evidence.
There you go. I mean, that's fair enough. You can put
But it was those overarching comments I made right at the beginning of my
right.
summation.
Anyway, that supports what the reference to us buying a brand.
Yes, without using necessarily the word brand. I don't want.
Well, yes, but we've got to be a bit careful about this. So look at paragraph 6. Last sentence. Ms. Adams also has a significant social media profile and has written 2 books in collaboration with her friend and colleague, Ms. Saja Sawala. So that apparently is referring to her professional status as of the date of the decision.
Yes.
Rather than what she'd done as of the date of the contract in question. I mean, was her social media profile significant as it's described as at 16th of March 2015? We've got no idea.
This court has no idea, but given the history of loose women having predated the BBC,
Yes, one can readily infer the situation, yes.
There'd be no, yes.
That's what gave her the profile.
All right.
My lord, would you excuse me one moment? I'm being reminded of paragraph 57G in the evidence,
Thank you.
which is page 150. J. 57J.
J.
Apologies, my lord. Page 161.
Yes, there's a brand.
Yes.
I'm grateful to those behind me.
But again, she currently had around 133,000 followers. So that's looking at the position as at the date of the decision.
Indeed, but I would suggest that.
I think.
But so if one's going to look at turnover and relative turnover, that's also going to be known only after the event. It's up to a tribunal to decide how much weight to give to it, but it puts the colour on the.
Yes.
My lord, I cut across.
The difficulty here is without seeing the evidence, we don't know actually as at what time this is being given. I mean, it may actually be before and after the start of the relevant contract.
Yes. Well, in any case, it's plainly obvious that Ms. Adams had a high profile, not just over the periods of the contracts, but for many years before that. So
Indeed.
these details don't help.
On this particular part of my submissions, what I want to say is the hypothetical contract, if one looks at the reality of the situation, which my learned friend was urging you to do, the reality is that this was one incident, or 2 incidents, because we're looking at 2 contracts, in a wider self-employment. And that is essentially, on the facts of the case, our case.
Right, now, how are you getting on?
Probably roughly where I'd want to be. I've now done the main part of my submissions, which is
Right,
the
so
law.
you've established that that submission is endorsed by authority. That it's a submission that you're entitled on authority to make. Right. So where are we going now?
What I intend to do now is to address the 2 grounds of appeal in turn, as in taking the court through the paragraphs of the skeleton argument,
Yes.
as slightly enlarged upon yesterday. But they should be much shorter,
Yes.
subject, of course, to your lordship. I would be very surprised if that took me beyond 1 o'clock. And then what I would want to do is to briefly introduce the auto-cleanse point, make my submissions on auto-cleanse, and that will then lead me onto the control test.
Right, and when might we be hearing from Mr. Tolley next?
I would suggest that I'd be very surprised if I went beyond 3 o'clock, which, given that I lost an hour last night.
Right,
But I will aim to.
that all fits in, doesn't it? Right.
I will aim
Well,
to beat my own estimate.
We'll sit till 4:30, and council will ensure we don't sit beyond that. All right.
Great.
So the grounds.
17.1 erroneously adopted a test of whether Ms. Adams.
Where in the skeleton?
So it's in skeleton. I'll actually pull the skeleton up so I've got the page numbers as well. It's paragraph 17.1. Page 21 of core bundle. I would say, using the terminology and the way that the Upper Tribunal adopted the test, I would say there was no error. It's often used, as I've said, as a converse of contract of service. But if we look more precisely, because obviously we've got the headlines at 17.1, but then we have the expansion in paragraphs 18, 19, and 20. The instances cited by HMRC are where the Upper Tribunal was grappling with the fact that Ms. Adams, albeit through the respondent company, was undoubtedly carrying on a business on her own account. And for the reasons I've already submitted, that is a highly relevant factor. It is a key part of the wider picture. Do your lordships have any more on 17.1?
Yes. Sorry.
Do you have any more questions on 17.1 for me? Because that is my submission.
Fine. Right.
But I don't want to move on to 17.2 if you've got...
No.
17.2. This is effectively the Weight Watchers point. Approaching the third stage as though there were an evenly balanced starting point. Now, I have to stress it slightly carefully on this, because it was common ground below that we were following Mr. Justice Briggs' decision. Now, if your lordships decide that Mr. Justice Briggs overstated the point, then my learned friend's case falls away for another reason. But I'm going to...
You don't have a respondent's notice on that.
But we don't have a respondent's notice. As I said, we made the concession below. What we're doing is going to show that there is no misdirection by the Upper Tribunal. And what I'm going to do is take your lordships through the 7 instances, or the 8 instances, where the Upper Tribunal appears to express the test to be applied at stage 3.
Right.
If I could ask you...
Have you got a list?
I do have a list.
Right. Well, do you want to give us the paragraphs before we walk through them?
I'm happy to do so, my lord.
Yes.
Paragraph 35, sub 2.
Yes.
72. 79. 89. Twice in 108. Twice in 115. And 116. And my learned friend's submission all turns on the example in paragraph 81.
At
81. 81.
So those you put into battle against 81.
Indeed.
All right. Do you want us to look at those?
Because 108 is actually at the start where the judge actually considers this, doesn't it? And
Absolutely.
That's where he says, prima facie conclusion, consider whether there is reason to displace it.
That is my
That's
submission.
how he starts the actual reasoning with that statement of the principle.
And the conclusion is similarly worded. Paragraphs 115 and 116.
Right. So your submission is that whether Weight Watchers is or isn't right, this decision is Weight Watchers compliant.
Indeed. The other examples just make it even clearer what test the court had in mind. Sorry, I interrupted.
Yeah, that's fine.
Paragraph 81, on the other hand, is merely a signpost. But this is why I took to a test. The point is made in the skeleton argument. But this is why I took your lordships to those 2 cases in my opening submissions yesterday afternoon. At worst, in paragraph 81, the Upper Tribunal can be accused of infelicitous wording. But if it's clear that the Upper Tribunal directed itself correctly, argument has no merit. Paragraph ground 17.3, paragraph 17.3 of the skeleton argument, third limb of ground 1. Here there are two challenges, and I'll deal with them separately. First, did not limit the analysis to the third stage of the relevant term of hypothetical contracts.
We've really dealt with that one.
But what I will also throw out is, slightly rhetorically, is if one focuses solely on the contractual terms, it would be almost impossible to find a term that is inconsistent with an employment contract. Piecework, which could be considered to be your efficiency, that we see from Nethermere is consistent with employment. You can be an employee subject to piecework. So each of the factors that my learned friend would like to rely upon can themselves be consistent. It's very hard to think of a term in a contract that is in itself manifestly inconsistent with employment relationship, which is why you need to look at a picture. I don't know whether your lordships would require me to give further examples as to what could theoretically be in that mix, but
No, please go on.
It's probably, my learned friend has in his skeleton argument, paragraph 29, a certain number of factors. I have addressed a couple of them, but I would just say that all of them, whilst they might be a pointer to employment or self-employment, none of them is inconsistent. We say that focusing on only the terms of contract makes stage 3 meaningless, and Mr. Justice McKenna said it was the most important, or said it was an important step. As for the second part of 17.3, the complaint is that the Upper Tribunal failed to consider all the terms of the hypothetical contract when carrying out the third stage.
The third stage.
The third stage.
Yes.
As I've already made clear, the correct approach is to look at the overall picture, and I submit the Upper Tribunal did that in 111 and 112. But if we then examine paragraph 31 of my learned friend's skeleton argument, we can see that the matters that the revenue would like the Upper Tribunal to have considered ultimately boil down to control and mutuality of obligation, which I'm not saying are totally irrelevant, but at the end of the day, they're just repeating themselves on stages 1 and 2. But I would also bring to your lordship's attention one passage from Weight Watchers, which has no bearing on the Weight Watchers test, as we might call it, or the Weight Watchers wording. But at paragraph 111, page 476 of the authorities bundle.
Sorry, which page again?
476, my lord. The particular passage is the whole of paragraph 111. I just want to bring to your attention the last 3 lines, the final sentence. There is no point setting out all the other contractual provisions merely as the preface to a conclusion that none of them constitute sufficient contraindications. So just saying you've not mentioned this is not even on the Weight Watchers approach the correct way. I also emphasise that not every factor, even if it does come from authorities such as market investigations as endorsed by the Privy Council, is relevant in every case. And slavishly trying to funnel in particular factors puts too much weight on factors which aren't necessarily relevant. Subject to any questions that your lordships
Well,
have.
yes, I think what is said about the way the Upper Tribunal dealt with this is that they really didn't look at the contract at all, apart from to refer to the 160 shows and the amount of time that necessarily took up. What they did seem to focus on is a sort of, if one goes, paragraph 114 of the Upper Tribunal decision.
114.
Yes, paragraph 114. Is where they do it, where the Upper Tribunal does refer to the contractual term about the 160.
Yes.
Minimum 160 shows, a good proportion of her available working time. Paragraph 115, those figures are significant. And then the Upper Tribunal then goes to Ms. Adams' evidence and the fact that audiences are fickle and so on and so forth. But I mean, this was a contract for 12 months. Of course, it couldn't be, might well not be renewed.
Mm.
But there doesn't, I'm not quite sure how they're grappling with the facts of the particular contract here. I mean, what does it really matter that audiences are fickle? I mean, employees can, businesses can be fickle. They can go out of business. So what's the real significance of the points that Upper Tribunal is making in 115?
But that's the point, my lord. Businesses are fickle. This is a business relationship in the context of a business.
No, when I say businesses are fickle, I mean if someone is an employee, well, that company may go out of business. They may find they're in the wrong market or whatever it is. Conditions change. I mean, everyone is subject to varying degrees of uncertainty. Some employees are subject to very high degrees of uncertainty.
I accept everything your lordship is saying. But the Upper Tribunal, which at this stage was the fact-finding tribunal, or the decision maker,
The decision maker.
the decision maker, was.
But what is the relevance of what is said in 115 to the decision they have to make?
It's emphasising the temporariness. Yes, it's a year, but it's only a year. And in the course of a professional career, a year might seem a long time when you're living it. But beyond that, it is just 1 year in a business that has been going on for 25. Or no, then started in the mid-90s. So 20 years by the time the contracts in question came in.
How does that tell you whether in 2014 Ms. Adams has or has not entered into a contract of employment? The fact that she may have been in business on her own account for the previous 20 years.
It does not determine.
And that it's a potentially fickle business.
It's the context. It's the background to the picture. I'm sort of hesitant to sort of overplay the analogy, but
can I follow up the point by putting the same question in a slightly different way? Because if you go on to see the next sentence, even ostensibly successful and popular shows like Loose Women could go off air for 12 months. Now, query the relevance of that. Let's assume it is relevant. They then say, understood in those terms, we do not consider the stability and economic dependence which the hypothetical contract afforded to be inconsistent with the conclusion it was entered into in the course of Ms. Adams' profession as a freelance journalist broadcaster. Well, surely the logic is the exact opposite. If it's relevant that even a successful and popular show like Loose Women could go off air for 12 months and therefore Ms. Adams regrettably would earn nothing, then the fact that she's been given a 12-month contract with a minimum payment of £155,000 surely indicates a high degree of relative stability and economic dependence from this contract, and surely that does constitute, on this reasoning, a pointer towards employment.
I'm not, with respect, I'm not saying the Upper Tribunal is actually saying what your Lord is deducing from it. What it's saying, with the background, as I left it with my Lord Sir David Richards, we have this contract. As your Lordship says, for that 1 year, it gives the Adams some financial stability. That's possibly something that could be inferred. But it was still not sufficient to displace the prima facie conclusion. Sorry, it still fitted in to the overall picture. So it was not inconsistent with that picture. It didn't stand out as so stark. But this is clearly something that has a new badge. So I think I was going to allude to an example of me as a self-employed barrister suddenly took on a teaching role at a university, I believe. I think it was the Sidey and Phillips case, which
Yes.
was similar to that. That could be so different in its nature that it's outside the net. But it's my existing profession is still nevertheless a relevant consideration, but one has to then weigh up all the factors. What the Upper Tribunal has done is said, okay, we can see certain pointers, but actually we still find that we are magnetically attracted to the conclusion this is part of the existing wider business. Can I just?
Were you just about to?
I'm just about
take
to
this
make a
point
further
forward,
submission,
yes.
if that's okay, my
By
lord.
all means.
I'm being reminded that obviously, as these contracts were, the first of these contracts was being drawn, we're looking at the period up from 2014 instead. This contract starts in 2015. Ms. Adams was working just 1 day a week with multiple other engagements.
Right,
But not in the BBC. She was down to 1 day a week at the BBC
in the previous year.
in the previous year.
We're looking at 20.
We're now looking at it, but I would say you have to look at the full context. You can't simply take a blinkered approach to the year in question.
Well, obviously, both parties knew that under the previous contract it was 45 or 48 shows
Yes.
in a year. But how does that affect the analysis on a contract where it's ramped up to 160?
It's just a factor that has to be taken into account when drawing the picture.
As you say, it's at this point that the Upper Tribunal remakes the decision.
Yes.
And we're here in the paragraphs that you've taken us to on page 108.
Indeed, yes.
Starting at, I think, paragraph 111.
Indeed.
And running through to paragraph 117.
Yes.
It is in those paragraphs that are to be found the reasoning for the conclusion. And anything else, as it were, is simply the run-up or the setting of the scene or the recording of the submissions.
Indeed, yes. And summary of the facts.
And summary of the facts. So, right. So looking at 117 to 111 to 117, could you help us by just extracting what factors at the third stage did the UT identify that positively supported a case of self-employment, non-employment rather? What factors did they consider pointed the other way? How did they carry out this balancing exercise? could you just extract its reasoning for us as you see it?
I think I would submit that the starting point is those two subparagraphs in 111.
111.
Indeed. So 1 and 2, sub 1, sub 2. Because, as I've already alluded to this morning, the way the case was put, and I continue to put, what takes this case, what marks this case as clearly self-employment, is the factual context of an existing self-employment.
Well, I mean, your argument has been it's relevant,
Yes.
but you accepted it was not determinative.
It's clearly not determinative.
No.
But when, if I can introduce the officious bystander, which is possibly, if what someone says, in what capacity is this contract being taken on? Is this part of the wider self-employment, or is this a new venture under employment? I would submit that the officious bystander would generally say, this is clearly, obviously part of the self-employment. That is,
Well, but the officious bystander would have to read and analyse the terms of the contract.
indeed. But
That's,
what are
we
what?
don't see the... Anyway, you answer...
What
I
are
mean,
the
well,
key-
I mean, I think my lord has asked the
Yes.
question, what is the Upper Tribunal? They don't refer to the officious bystander. So what is the Upper Tribunal's reasoning, do you say?
They set the facts. 112 acknowledges that's not determinative.
Right, just pausing a little at that stage. They start off by giving what you accept was a Weight Watchers compliant self-direction about the fact that here we have mutuality and control. So they took that to start with, and then they start to look at matters in the round at the third stage. They refer in 111, 1 and 2 to the quality of Miss Adams' previous career
Yes.
and the nature of her activities not for the BBC,
Yes.
right? So they start, as it were, the pushback with those. Now where do they go to?
They acknowledge
But that's not it.
that's not
Not
it.
enough, yes. So what do they then say makes it enough for you to succeed in showing non-employment?
They say 113.
Can I,
Repeat.
just before you go,
Of course.
it's right, isn't it, that at the last two sentences of 112, they set themselves their task.
Yes.
Yes.
It's therefore necessary to consider. So they're saying, well, they're focusing on Miss Adams' activities
Yes.
for the BBC under these 2 years, with her activities performed for others as an independent contractor. So what is she doing?
She's presenting. She's acting as a journalist.
But is that enough? You could be, I mean, you could be doing exactly the same thing as a self-employed journalist and as an employed journalist.
Absolutely.
But so, what is the importance of the activities, therefore, as being the determinating factor?
Because if one were to, I'll take away from Ms. Adams and put it myself, if I started waiting tables, say, well, I'm a self-employed barrister, so clearly when I wait tables on a Saturday evening, I'm...
But I'm sorry, no.
Similarities.
Let's go back to a journalist.
Okay.
I mean, clearly there are many self-employed journalists and many employed journalists
Absolutely.
doing the same thing.
Yes.
So their activities are not going to tell you whether they're employed or not.
No. But it's
But
part-
that is what the tribunal is there saying it's necessary to consider.
because
I mean, it's all right. Yes, go on.
when carrying out a qualitative exercise, there are going to be different ways of carrying it out. This was because this is a case where the existing self-employment is so clearly a major factor. It's the obvious starting point.
But I appreciate that, but I'm come back to my question. What is the relevance of the activities?
Because if one were carrying out a different kind of, a wholly different, non-complementary kind of activity.
But you might be doing that. I mean, you have the same question. Are you doing it self-employed or employed? I mean,
May I, Lord, take a step back?
So, Miss Adams, we know, for example, she does some writing.
Yes.
She might write columns for magazines as well as the books, or
Indeed.
she speaks at corporate events and so on. And these are all different activities.
But that's why I use the word complementary.
Well, I understand. I do understand.
My Lord, may I take a step back?
Anyway, my question to you is why the activities, why they say it's necessary to look at the activities to determine whether she's undertaking those activities in a self-employed capacity or an employed capacity.
The way I would interpret what the Upper Tribunal is saying is if the activities are so clearly in line with what's happening elsewhere, then that would be a further reinforcement that this is part of the ongoing engagement.
I mean, they seem to be saying, the only thing that they seem to rely upon to get this over the line, as far as you're concerned, is that Ms. Adams is a freelance sort of person.
Carrying on a freelance activity over a continuous basis, of which, when you take a step back, this is clearly one part.
Yeah, but they appear to accept that the nature of the contract is a pretty employed sort of contract, but that somehow Ms. Adams' profile as a freelance sort of person means that it isn't to be treated as an employed sort of contract.
I would submit that it's only employed on the basis that it's on the Weight Watchers approach, because it's got through stages 1 and 2 of ready mix. There's nothing else inherently employee about that contract.
And then in 113 and 114, they do go on to consider the economic dependence.
Yes, could I just ask a question about that? Sorry to interrupt, my lord. Because I wanted to ask about the last sentence in 113. By parity of reasoning, any economic dependence on the BBC in the particular tax years under appeal should not automatically lead to a conclusion that she would have been an employee in those years. It has to be understood in the context of Ms. Adams' profession as conducted in the surrounding tax years. Now, do you defend that reasoning?
Entirely.
All right, let's take subsequent tax years. Are they going to be relevant?
They will be relevant to the picture, indeed, yes. And
right, so your employment status can be determined by events that happen in later years. Is that right?
I would say yes, my lord.
Okay. But what that leads us to is that what drives the decision is that statement in combination with the last two sentences of 115. HMRC accepted that in the tax years 2013 and 2014, the hypothetical contract was not one of employment. Don't consider the degree of economic dependence in just two following tax years was sufficient to depace that conclusion. So what drives the decision is their understanding, wrongly, that HMRC had conceded that the previous 2 years were not of employment, and they're thinking that that's the key question that they have to answer, is whether the degree of economic dependence in the two instant tax years was sufficient to displace the conclusion.
I will not defend the Upper Tribunal's wrong inference. It didn't have the revenue skeleton from the first year, so it made a guess and it made a wrong guess. I'm not going to defend that. But what we'll see when we move to paragraph 160 is that it was not the sole deciding factor. So even if the Upper Tribunal wrongly, and I'm not conceding it actually reached the wrong decision. I'm just because I don't actually agree with the revenue necessarily fairly stated their reasons, but working on the assumption that what they said in the skeleton to the first year was 100% correct. Even if the Upper Tribunal took that on board, it was only one of two separate limbs that led to its decision. So the error, if it made an error, is not fatal to the overall decision. And we see that in 116.
Again, 116 focuses on her activities.
And I would submit that in a case like this,
What do they mean by activities?
her activities as a self-employed journalist. It's all the Lord Walker described a trade as more than a bundle of sticks, but effectively it's that bundle of sticks.
But I find this quite tricky in 116. I mean, they say we do not consider there was any relevant difference between the characterization of Ms. Adams' activities under the 2015, 2016, 17 hypothetical contracts and little to her other activities as a self-employed journalist and broadcaster in other tax years. Well, they didn't have the contracts, did they, for her other activities as a self-employed journalist and broadcaster?
The Upper Tribunal had the transcripts, the meeting notes,
No,
the
no,
witnesses.
of other.
Oh no, but it had
In other, not with the BBC,
No,
but
no,
with others.
But it had all the evidence that the
Well, what's
first
the evidence of her contracts?
not the terms of the contracts, but the nature of the program.
But it's the terms of. I mean, I think you accept that the terms of the contracts are highly material to.
But
I mean, you don't deny the materiality of the terms of the contract to the stage of the inquiry.
not at all. But ultimately,
I don't know quite how they can have come to this. I mean, so they're not talking here. They can't be talking about the terms of the contracts, are they? The structure under which her activities are being done.
the nature of the activities is what kind of medium are you working on?
Yes, but I
Frequency.
come back to my example of a journalist. I mean, they say her other activities as a self-employed journalist. I mean, they're making that assumption it was all self-employed.
Yes. But my
And
lord,
they're saying that the hallmarks, we do not consider there was any. Well, I mean, I think they have to be saying here, don't they, that the contracts for 2015-16, since they didn't have the other contracts, the contracts, hypothetical contracts in question, have all the hallmarks of self-employment.
whilst I say that the terms of the contracts are important, I do not suggest that one looks solely within the prism of a contract law. One takes the holistic view.
Well, I appreciate that, but what is troubling me about this is that apart from the reference to the number of shares, the economic consequences of that, which I accept to be significant, there's no analysis of the contract terms at all.
Well, there is earlier when after the auto claims matters resolved, we have a lot of analysis as to
Which paragraph?
control. Control starts at paragraph 99.
But they could, yes.
But the actual contract, or the hypothetical contract as determined by the Upper Tribunal, in the 60s, we have sort of discussions as to what goes in and what goes out.
Well, that's the, yes.
Yeah. So
But they don't,
but
for example, bring that in at this stage. I mean, the two clauses which, where they reverse the auto claims, they don't mention those clauses.
that's because they're effectively critical on the control point. And
Refer to them there, do they? Yes, they say it's had qualified right of first.
And what I would say is, at the end of the day, and I'll repeat the point about not looking at this through the prisms of a contract law. what are generally the most important aspects of the contract? How much, how often, when, for how long? Beyond that, terms such as you will not, you'll comply with Ofcom, you won't bring us into disrepute, they're pretty neutral in this analysis. And as Mr. Justice Briggs then was said, you don't have to list every factor just to strike it out
You
again.
may not need to list every factor, but it's a bit startling that none of them, I mean, some of them might well be helpful to Ms. Adams. I mean, for example, under the, I mean, clearly the work she does doesn't require the provision of equipment, but what it does require, because she's on television, is the
Radio
provision
for this particular.
for this one.
Yes, this is radio.
This is a radio. I mean, all right. Why in that case?
This analysis by the Upper Tribunal is in the context where they are upholding by different means the conclusion of the First Tribunal.
What they're doing is remaking the
I know,
decision.
remaking the
and
decision,
leaving
but
it in.
against a background. And in many respects, it might be said, and this is not, for my purposes, criticism of the Upper Tribunal, but that if one looks at the First Tribunal at 102 to 129, which is at page A175, in many respects what the First Tribunal did was a richer exercise, a more conventional exercise in which I make this as a rather sweeping statement,
Yes.
but it might be thought that all the conventional considerations are brought into account. And one sees it over a quite substantial period with a lot of contract terms being taken out, listed, turned over, considered, commented upon, to reach the same conclusion. Now, I mean, to what extent are we entitled to view the matter when considering what the Upper Tribunal did on the background that it was standing on the shoulders of the FTT, even if it didn't say so?
I certainly wouldn't dissuade your lordships from taking that approach.
Dissuade.
I wouldn't dissuade.
Wouldn't dissuade, right.
And in fact, there was a point, paragraph 118
Of
of the upper.
yes, what do they say?
We're conscious we've differed as to the terms of hypothetical contracts. In these circumstances, we carefully considered whether we should remit back. We decided not to because we derived enormous assistance from the careful way in which the first tier found facts and set out its findings and decision to which we pay tribute. Those findings have enabled us to adopt what we consider to be the more proportionate course of remaking the decision. Given that the task of the third stage of ready-mix concrete involves a multifactorial analysis, we are assured that our own independent analysis of the fact and counterfactual matters in issue led us to the same conclusion as the first tier.
But they emphasise that it's their own independent analysis.
They
haven't in any way relied upon what the FTT did at stage 3.
No, but because they've come to the same conclusion, they've let it rest there rather than say, oh, we've come up with an issue and then let's go back. So I certainly wouldn't dissuade. They clearly had the first tier's decision fully in mind. But what I would say is the key facts in most of these cases where someone is carrying on an existing business are, does it fit into the existing business? How much are you doing? Where are you doing it? When you're doing it? And I would submit that analysis of every other contractual term will lead you
Right.
to
Well, let's suppose we weren't with you on that particular submission, and we thought that the UT approach was not adequate,
yes.
or indeed wrong as a matter of approach. In what circumstances would the different analysis conducted by the FTT come to your aid?
It would effectively, once you've dealt with the auto cleanse point, which is more or less washed out when it gets to control, the first tier's analysis reaches the sensible, common sense view that this is part of the self.
Yes, but if you're right on either of your respondents' notice points,
Yes.
then the Upper Tribunal decision falls away anyway, because
Absolutely.
they weren't entitled to interfere with the FTT decision.
Indeed.
So we have to assume for these purposes the respondent's notice points don't succeed.
And
The question then is, suppose that the appeal succeeds to the extent that it's shown that the Upper Tribunal's decision is also flawed. So where do we then stand, given that both of the lower tribunals on that hypothesis have made decisions which are flawed?
My lord, are we asking now whether it's a remitter question or not?
That's really where it needs
That's
to.
where you're getting to. My submission on remittance is not. This is where I do part company from Mr. Peacock last week. With respect to him, I will say that there are many occasions when it is appropriate for this court to make its own fresh decision without remitting, for the reason the Lord Justice Peter Jackson made clear last week: time and efficiency. However, if your lordship was minded to go down that route, then I would say that the analysis towards the end of the first tier's decision is secure, notwithstanding the auto-cleanse point. Because the auto-cleanse point ultimately focuses on control. So,
Right, you ignore the first call point indeterminate stage 3 because you've brought it into account in stage 2.
I'm not ignoring it, but
Stage 3, you're ignoring
Mr. Justice Mann's decision in Matthews, which I read up this morning, says it doesn't get ignored altogether. Not
it. No, that's right. Well,
but what I'm saying is,
I mean, it's not, you can't really invite this court to make a decision just sort of accepting what the FTT can do. Particularly when as things stand, it was a flawed exercise.
but the question is whether the factors in paragraph 102.
Sorry.
Yes.
Would you be saying this should be remitted or not?
My bottom line is that it should be remitted.
It should.
It should be remitted. But I was just giving your lordship some comfort that if you decided to remake the decision,
I think that's what I'm anxious.
We wanted the bottom line.
the bottom line is it should be remitted to whichever tribunal it is, based upon where you are on the appeal on the respondent's notice.
Understood, but that's obviously a separate question.
That's a separate question.
But I take it your client is conscious of the fact that remittal would lead to a further hearing.
Bitterly.
And potentially, worst case scenario, a further appeal.
My client is bitterly aware of it. However, which is why,
In which case, the way to save costs is for this court to remake, assuming, of course, this is all dependent upon the hypothesis
Absolutely.
that I've already mentioned, and we may never get there.
Yeah.
But if we do get there, do you really want the costs of a further hearing?
ultimately, I leave your lordships to decide how your lordships consider the
But a key
Various-
factor is the desire of the party.
The desire of the party is to remit. However, I do leave this court the option of looking at the
Right.
facts.
Well, should we just break this discussion, and it's the sort of thing which you might like to have
It might
some
be helpful.
discussions and see where your client's position rests. But I echo what my lord has said, that this is an entirely hypothetical discussion. It's simply that by the time we get to the end of the hearing, we have to have covered all the bases. And
No,
this is
I'm
one of the
great.
bases that we need to. It's not an indication to the least extent of where we might end up.
I am grateful for that reassuring.
All right.
behind me.
Now, after lunch, you'll have an hour, and so making allowances for our interruptions, you'll decide how you want to use that.
I'm very grateful.
All right.
Would it just help if I give you an indication as to where I am? I've got about one line to say on ground 1,
Yes.
little on ground 2, and then it's straight on to
Jolly good.